We are beginning with this fourth session, and I myself, Suparna Vinayak, Assistant Professor, Amity Law School, Amity University, Uttar Pradesh, welcome you all to the International Conference on Comparative Law, Amity Center for Comparative Legal Studies, under the aegis of Amity Law School, Noida, Amity University, Uttar Pradesh, India, in collaboration with the School of Business and Law, Edith Cowan University, Western Australia, is delighted to host the 4th Annual International Conference on Comparative Law. Carrying our legacy ahead, and I am now beginning with our 4th keynote session. To begin with our keynote profile of Professor Stephen Wagner, who is the director of Max Planck Institute for Legal History and Legal Theory, Germany. Sir is a director of the Max Planck Institute for European Legal History in Frankfurt. From 2003 to 2015, Sir has held the chair of comparative law at the University of Oxford, where he was also the director of the Institute of European and Comparative Law. Apart from the transnational commercial law, his main research interests are in the European legal history, comparative law, and legal method. Sir has taught and lectured extensively in Australia, Europe, USA, and South Africa. To his contributions, the publications also include the commentary on the Unidroit principles of international commercial contracts and EU's Commune Casebook for the Common Law of Europe cases, which are study materials and the text on contract law. Sir, I humbly request you to address us.
Thank you very much, Professor Suparna, for the kind introduction. It's been a pleasure to be with you virtually. I have also been teaching in India, actually, next door, so to speak, at NLU Delhi a few years ago, when I was a visitor under the visiting program for foreign lecturers. Very much enjoyed my time there, although I have to say I picked the wrong time of the year. Everyone warned me, but I could only go in May, and it was a very hot experience, is perhaps the best way of describing it, but I very much enjoyed that. Now, for my short keynote today, I thought I should present a major research project that I've been running for a few years now with many colleagues in Asia, and that I think would be merited to be made a little bit better known across the region. The project is called The Studies of the Contract Laws of Asia, and I'm just trying to share my slides with you, which went a minute ago, but now I get a different, who can share, all participants. I get a different box popping up. There we go. Sorry about that, but here we are. The project is called Studies in the Contract Laws of Asia. It's been running for a number of years, and it will also continue to be running a few years. The 4th volume of it was just published last summer, and you can already see here from the cover, all the books from the series are published with Oxford University Press, and my co-organizer of this project is Professor Mindy Chen Wishart, who is the professor of contract law at the University of Oxford. We basically decided to do that project when I was still the professor of comparative law there. And for each volume, we tried to get a 3rd co-editor from one of the main Asian jurisdictions. And this volume, volume 4, was co-edited by my esteemed colleague, Professor Hiro Sono from Japan. So I can only give you a very short overview in these 15 minutes. I would like to familiarize you with the project, show you which jurisdictions we cover, what the aims and the methodology of the project are. These are, of course, always crucial questions if you talk about comparative law. And then give you at least a very tentative overview of some of the findings, although those findings tend to be much more at the micro level, but there's no way I could even summarize those in such a short presentation. So as I said before, the project has been running for a while. It began in 2014. The first volume was published in 2016. We just published the fourth, and we've got 2 more to go. And you can see already, if you look at this list of volume titles, this looks very much like the table of contents of a contract law textbook. So what we did is we divided up the area of contract law into chunks that are familiar to contract lawyers from all jurisdictions, and cover them one after the other. So that's in a way a fairly traditional approach. When we talk about the coverage of jurisdictions, you can see that perhaps the name of the project, Studies in the Contract Laws of Asia, is a little bit over-inclusive, perhaps a little bit over-ambitious. What we actually have is a comparative project on the South Asian, the East Asian, and the Southeast Asian jurisdictions, but in that regard, we are relatively comprehensive. That is not to say that the other contract laws of Asia would not merit further scrutiny, particularly, of course, those of countries that still have an enormous influence of Sharia law. Sharia law would have been really important and interesting. As with all big projects, sometimes you have to be pragmatic, you have to find contributors, you have to rely on your contacts, and this is basically what we ended up with. However, it's not meant to say that the project is under-ambitious. I would say, after having worked on it for many years now, I would say perhaps it's even a little bit too ambitious, because we sometimes just reach our limits. And if you look at those 13 jurisdictions that we cover, you can see that they're by no means insignificant. They include 2 of the most, or the 2 most populated countries in the world. Also, in terms of economic power, some of these jurisdictions are enormously successful, of course, particularly Hong Kong, Singapore, Japan. You have the so-called Asian tigers in the mix. So overall, the project covers nearly half of the world's population, and any economic power that is, at least on average, above the global average economic power. Now, having said that, the latter figures are slightly distorted, because Singapore here would count as much as India. Of course, in India, you'd have to multiply by 1.3 billion, whereas in Singapore, you only have to multiply by 5.5 million. Still, I think we do cover an important part of the world, and perhaps most importantly, it's a part of the world that has been neglected by comparative studies, or that has only focused on comparative studies of these individual jurisdictions with other jurisdictions in Europe. But there has never been such a comparative project that only included Asian jurisdictions. And if we talk about the economic importance, and I think we are in the section on business law here, I think it's fair to say that this economic importance of those 13 jurisdictions is to be expected to increase rather than decrease. This is a graphic from the Financial Times before the pandemic, where they basically predicted that the combined GDP of Asia would surpass the combined GDP of the rest of the world in 2020. That may have been held up, that trend may have been held up by the pandemic, but it is a trend that is bound to continue. So we're certainly looking at a number of jurisdictions that perhaps have the best ahead of them. Now, what is the methodology? As I said before, in a way, we've been fairly traditional. This is not a project where you would like to test new avant-garde methodologies, simply because the terrain is so uncharted in terms of comparative exercises. So what we have is, for each volume, there you see the beginning of the table of contents for volume 4. For each volume, that is, you remember, representing or dealing with a slice of contract law in terms of doctrinal contract law. For each of these slices, we've sliced them up again into even smaller sub-areas, and then have national reporters covering them. So, for example, this is the beginning of the table of contents of the volume covering invalidity of contract. And there you can see there's 2 chapters on Chinese law, both written by distinguished Chinese contract lawyers, one on the doctrine of mistake, and the other on cases that you might summarize under the rubric of duress and exploitation. If you look at Hong Kong, again, you have 2 chapters, one dealing with mistaken misrepresentation, and the other with what we call reprehensible conduct, threats, and unfair exploitation. So these are country reports, as I said, in a traditional comparative sense, written by experts from within the jurisdiction. They're based on a common questionnaire that the editors for each volume established, where we basically ask them what to look out for, and where we also include a number of hypothetical scenarios. They're often based on real cases, but what we'd like to see is, would a court in Shanghai, or what would be the outcome if a court in Shanghai gave judgment on this set of facts, and what would be the outcome if a court in Mumbai gave judgment on this set of facts. Those of you who've done some comparative law methodology will be familiar with this. Is the so-called Trento methodology, based on the work of Schlesinger, famous American comparative lawyer in the second half of the next century, where you look at parallel scenarios, hypothetical scenarios, and you try to predict how they would be decided in different jurisdictions. But there's also a more descriptive account of what the law actually is in those jurisdictions. And that is of enormous value, because most of these jurisdictions are not English language jurisdictions, so there is nothing available in the English language, which is, of course, the most widely used in international studies. So just having those, I would argue, solid accounts of these jurisdictions in the English language is already a major achievement. Perhaps it's not so important for the likes of Hong Kong and Singapore, even India, because they are, of course, all or almost all of the legal literature is in English. But for all the other jurisdictions, that is actually quite a step ahead. We then have a concluding comparative chapter written by a distinguished international comparative lawyer. In this case, of volume 4, it was my colleague, Professor Hugh Beale from the University of Warwick in the UK, who's one of the leading comparative contract lawyers in Europe, perhaps in the world, who tried to pull the strings together and give a more analytical comparative background. And each volume then concludes with a relatively comprehensive bibliography, particularly of literature on these jurisdictions, that is available in the English language. So what are the 3 broad aims of the project? First of all, it's literally just an exercise in mapping out what is there, a very descriptive exercise, making outsiders from these jurisdictions aware of what they actually, what these contract laws look like. I think there's nowhere that you can, for example, read on the Vietnamese law of contract in a Western language in a comprehensive way. This it's also very difficult, say, with the law of Myanmar. The second aim is that we try to instigate an intra-Asian comparison contract laws. As I said before, that simply hasn't been done before, because traditionally Asian comparative lawyers have rather looked to their European source jurisdictions. So Indian lawyers would mostly compare with English law and other common law jurisdictions outside Asia. Indonesian contract lawyers would mostly compare with Dutch law because their contract law is based on Dutch law. Chinese contract lawyers would mostly compare with German and US contract law. So this intra-Asian comparison has so far not happened. And the third broad aim links to this focus that all the Asian contract laws have on their origin, because all those that we look at have what we call a source jurisdiction in Europe. They're based on one of the three major European legal families. And this is how I'd like to conclude, simply to make you aware of these links and connections with Europe. So we have, of course, a number of jurisdictions that are firmly in the common law tradition. India is the most important of them in terms of quantity. Perhaps Hong Kong and Singapore are the most important of them in terms of commercial significance for world trade. From Indian law, you have derived the Malaysian Contracts Act, and you also have the contract law of Myanmar, which is identical to the ICA 1872. So these form a kind of family within Asia that's firmly within the common law tradition. But what our project shows is that there are very important differences between them. You couldn't say that Indian law is remotely, contract law is remotely identical with, say, the contract law of Singapore, because each of these jurisdictions has developed in its individual way and has somehow moved away from the English model. Also, you see the Philippines there in a kind of strange rows. So they're a mixed jurisdiction because they represent a mixture of Spanish contract law and US contract law based on the colonial history of the Philippines. The second major legal tradition in Asia is the Germanic tradition, starting with Japan, which adopted the draft civil code of Germany in 1898 and exported this model to what today is South Korea and Taiwan, and also to the Chinese mainland. Also, the law of Thailand is firmly based, at least in the area of contract law, on the German civil code. And the third legal tradition that we have is the Romanistic tradition, with Vietnam, a former French colony, and Indonesia, which, as I said, has its contract law based on Dutch contract law. And then again, Dutch contract law until recently was simply a translation of the French Code Civil. And as I mentioned before, the Philippines have a substantial element of Spanish law there. So you have very different genealogies here in Asia. And the fascinating thing is to observe how these individual jurisdictions have moved on from their often colonial or at least early modern origins, where they very often simply copied a European law and found their own distinctive ways of dealing with issues of contract law. And if you look into these volumes, you can really see that we drill down to the nitty-gritty. It's very detailed, it's very rich. Obviously, within the short 15 minutes that I have, I can only present you with this mix of traditions that we find here in the jurisdictions that we cover, and hope to whet your appetite for this fascinating projects. If you're interested, unfortunately, OUP are very restrictive with what they allow you to put you online. but we managed to convince them that the concluding chapter of volume 3 and also I think the introductory chapter of volume 3 could be uploaded on SSRN. So if you're interested in that, I'd invite you to have a look. Thank you very much for letting me present you this project.
So nice of you, sir, for this wonderful opportunity to and the contract, how it has to be dealt so extensively, where you embarked us on the remedies for the breach of contract, the third-party beneficiaries, and the way you are letting us know the contents of the contract and their unfit terms. So you have let us know the importance of comparative law in different parts of the jurisdiction, as you have mentioned in the highlighted picture, which has let us know exactly which is the vitiating part of the contract, which affects our contract. That is the consent on the mistake and the misrepresentation. You have also further dealt with the connections which we are here to develop with Europe and Asia, where we have to focus upon the mapping, the comparison of it, and further how to track it. Sir, your presentation was such an illustrious one for us to go with an eye-opener how to compare the laws on the contractual terms. Thank you so much for all the insights which you have given, which we have to draw, certainly to infer the meaning where different terms can be derived with different inferences and so the multiple interpretations. Thank you so much, sir. And now I begin with another speaker with this profile, that Umakant Varotil. Mr. Umakant Varotil is an associate professor at Faculty of Law, National University of Singapore. He specializes in corporate law and governance, mergers and acquisitions, and corporate finance. While his work is generally comparative in nature, his specific focus is on India and Singapore. He has co-authored or co-edited 5 books, published articles in international journals, and founded the India Corporate Law blog. He has also taught on a visiting basis at law schools in Australia, India, Italy, New Zealand, and the United States. Prior to his foray into academia, Umakant was a partner, sir, at a preeminent law firm in India. During that time, sir was also ranked as a leading corporate merger and acquisition lawyer in India by the Chamber's Global Guide. He has obtained law degree from Faculty of Law, National University of Singapore, PhD, the University School of Law, LLM, and the National School of India, University, Bangalore, India, for his BA LLB graduation. So I seek your opening remark for the session.
Thank you, Professor Vinayak, and rest of the hosts for inviting me for this session. And I'm really glad to be sharing some thoughts with colleagues on this panel as well. So I am going to kind of move forward and take the baton from where Professor Waganar left from a contract law perspective. And I'm going to focus a little bit more about my experience working on comparative law and moving on from a specialty point of view to comparative corporate law, because that's really what I'm focusing on currently. And I'll share some thoughts on where we stand today. So if we look at comparative corporate law, it's very clear that corporate law has an important role to play in society. And the role of corporations is also quite important. And it's also very clear that corporations are quite interconnected around the world, and globalization has an important role to play, which is why comparative corporate law becomes quite important. And those of you who are in India are very, very closely watching what's happening currently, because a research firm and a short seller in the US, a relatively unknown but important short seller in the US, has put out a report on the Adani Group, which has had a significant impact on the Indian stock markets, not just on the Adani Group, but also on the markets as a whole. So you can see that globalization has caused a lot of interconnectivity, which has positives as well as negative implications as well. Are you able to hear me clearly?
Yes, sir,
yes.
please.
Yes, sir. Yeah, so which is why the study of comparative corporate law is extremely important. And I'll just highlight a few things relating to that. So I'm going to preface my remarks by focusing on three important points. The first is to look at what are the significant theories when it comes to comparative corporate law. What do we see coming out from the literature? That's number one. Second one, linked to what Professor Wagner had also discussed, what is the state of comparative corporate law in Asia? So that's my second point. And my third point, I'll zoom in more like a funnel to see what's the comparative analysis in the state of corporate law in India. So we'll start from global, step down to Asia, and then further down to India. And I'll hopefully try and accomplish all these three in the 12 or 13 minutes that I have left. So when we look at comparative corporate law, there are a number of significant theories that exist. And I can't cover all the theories that exist, but I just wanted to talk about two important kind of concepts and theories or tools for comparative corporate law that have caught the attention of scholars and practitioners around the world. The first one is something known as the law matters thesis. And the law matters thesis basically came up by an analysis by certain economists called LLSV. So there are four economists. Each of their names stands for an acronym. LLS and V came up with this theory saying that yes, law matters regarding the importance of financial markets, and the better the legal system is, the better it's going to be for the financial markets and corporate governance in general. So the idea is corporate governance and ownership is dependent upon the level of legal protection that any legal system provides. So they try to establish a close nexus between law and financial development, and more importantly, law and corporate ownership and corporate governance. So this much is understandable. We all kind of understand that law is very important. But the LLSV thesis also goes on to make another claim, which is what is quite a controversial claim, which is that they say common law provides better access to capital, better corporate law, better corporate governance than civil law. And that has been something that's been questionable. And LLSV is by far the most cited work on the area of comparative corporate law, comparative law and finance. But quite a bit of it has actually been subject to challenge. So the citations are not so much about agreeing with that thesis, but about challenging that thesis, because there are many arguments as to why this distinction between common law and civil law may not always work, for reasons I will establish a little later. So it's not necessary that there's a clear distinction that can be made between the legal systems, at least as far as corporate law is concerned. And there's a lot of scholarship that's come out. There's a cottage industry challenging the LLSV thesis. So this is a fascinating start to think about comparative corporate law. Again, I don't have the time to get into the details of the LLSV thesis, but two important things to keep in mind: law matters, and secondly, common law matters more than civil law is their argument, which has been subject to considerable criticism. And the second kind of tool for us to think about is something known as the convergence versus divergence debate. So the convergence, or proponents of the convergence debate, argue that all corporate law will move towards one single approach, which is basically that corporate law is going to be shareholder oriented and based on long-term shareholder orientation, where you see a lot of companies with dispersed shareholding, pretty much like what you see in the US and the UK currently. So the proponents of the convergence debates, and this is primarily two US scholars called Professor Hansman and Professor Crackman. So they have this very important paper in the early 2000s called The End of Corporate Law. And here they argue that most systems around the world are going to become like the US and the UK, where long-term shareholder value is going to be the extreme approach towards corporate law. And that's really going to be the goal of corporate law. And again, like any other theory, this theory has also been subject to their own detractors, where many argue that this convergence is just a pipe dream. And it's almost not possible to have convergence, because we also have to think about local circumstances, local factors, local institutions, local culture that may have a role to play, which may actually militate against any form of convergence. And so there are many people argue based on the fact that there's a path dependence theory. Sometimes it's efficient to just follow what each individual system has been following rather than to just move towards a converged approach. And secondly, there may also be self-interested approaches where there may be those who are in control of the current dispensation who may not want to change at all. So for instance, in the Indian context, there's a lot of literature that says the controlling shareholders or promoters of companies actually like the fact that there's concentration of shareholding, not just in India, but even in other parts of Asia. So why would they give up their control and move towards a more dispersed shareholding that is there in places like the US? So these the tools or methodologies, both the law matters thesis as well as the convergence versus divergence debates, they're very, very topical. They raise very thought-provoking, very controversial ideas, but ultimately they have formed tools by which we can establish ways of understanding comparative corporate law rather than to look at it in vacuum or in isolation. So like I said, I've just picked a couple of these tools and topics for us to think about, but there are many others, but I'll just use these two to understand what is happening in Asia and then in India. So after having understood what these tools are, it brings me to my second point, which is what is happening in comparative corporate law or comparative corporate governance in Asia. And here there are about 3 points that I want to talk about, which is how did corporate law scholarship evolve in the Asian context? Secondly, who's driving the corporate law analysis from a comparative perspective in Asia? And has there been any regulatory push or legal or legislative push towards understanding corporate governance in these jurisdictions in Asia? And as Professor Wagner also mentioned, Asia is pretty heterogeneous in that sense. So what works in India may not work in China. What works in Indonesia may not work in Japan. But I think the idea of the scholarship is to understand what exactly matters in these jurisdictions rather than to try to argue that each of them looks alike or there are enough commonalities between them for us to understand them together. So how did Asian corporate law scholarship emerge from a comparative perspective? So the first wave of comparative studies actually came up from economic scholars. So many of you may not know, but or may know, but in 1997 there was what was known as the Asian financial crisis, which actually preceded the global financial crisis by about 10 years. And not many Asian countries were affected by this because, for example, I was at that time in India and we didn't pay that much attention to it because India wasn't really affected. But those in Southeast Asia and East Asia were significantly affected by the Asian financial crisis. And so many corporate law scholars got interested in the issue. Why did these companies, which were subject matter of these crises, fail? What went wrong in those companies? Did corporate governance have a role to play? So was there poor corporate governance in companies which failed? Were there related party transactions? Was there siphoning of funds by controlling shareholders? So these were the questions that people asked. And studies actually showed that companies which were poorly governed were affected more by the financial crisis than companies which were better governed. So there was some kind of a correlation that was established between better governance and the implications from the global financial crisis, because those who were better governed were affected less. And around this time, there was also another wave of scholarship where a lot of foreign scholars started getting interested in understanding Asia. So, for instance, in the 1980s, before the downturn in Japan, there was a lot of interest in Japanese law and Japanese corporate governance. So a lot of US scholars started trying to understand what is happening in Japan. Why were Japanese companies doing well before the bust in the late 1980s? And similarly, more recently, there's been a focus on China and India in the last 15, 20 years, because there's been a humongous economic development in these two countries. But at the same time, there's also been a wave of what I would call as indigenous scholarship. So there have been people within these jurisdictions also working on trying to understand what's happening in these jurisdictions. And that's an important role that local scholars have played as well. And what I find fascinating here, and again, this links quite well with the contract law approach, is that there is a two-stream analysis here. So historically, a lot of analysis about Asian jurisdictions were to try and see how each Asian jurisdiction compares with either the US or the UK, because the US and the UK have been exporters of corporate law, because a lot of other jurisdictions, including in Asia, have adopted or transplanted many corporate law principles into their jurisdictions. So the idea was, how do we see whether India fits with UK or does China fit with the US? So that was a kind of analysis. But more lately, similar to the contract law scenario, there's been a lot of intra-Asian comparison as well, which is to try and understand how India compares with Singapore, or how China compares with Japan, how Korea compares with Taiwan, and so on, right? So that's also a very interesting phase of analysis. And I've also been fortunate to work with a lot of corporate law scholars in the Asian region in trying to make this analysis in many areas of the law, including takeover regulation, independent directors, derivative actions, shareholder stewardship. So in each of these, there's been a bunch of corporate law scholars in Asia who've come together to try to understand what's happening in the Asian context. And it's all resulted in books similar to the one you saw on contract law, but not as part of the same series, but there's a lot of scholarship that's developed in that area as well. And then we also see something very interesting happening in the Asian context, which is also the emergence of a lot of think tanks. For example, there's something known as the Asian Corporate Governance Association in Hong Kong, which also looks at a lot of studies on corporate governance, and that's a more practical oriented approach. So it's not very scholarly or academic in nature, but they actually look at what exactly is going on the ground, and they even suggest legislative and regulatory reforms as far as laws are concerned. So for example, the Asian Corporate Governance Association has even put out reports on corporate governance in India in the past, and institutions like the Securities and Exchange Board of India, SEBI, have actually taken on board some of the suggestions. So that's also an important way of understanding what's happening in the Asian context. And the third is a lot of legal and regulatory developments where you see the transplantation of phenomenon that's happening elsewhere into the Asian jurisdictions. And here there is something to say about the law matters thesis, because it seems like law actually does not matter in the end, because in corporate law and securities law, a lot of the transplant is happening across the legal systems. So you see, for example, China adopting directors' duties of companies from jurisdictions like the US and UK, which are hitherto, which are common law systems, but we would always think of China as a civil law system. So there's a cross-pollination of ideas across these legal systems. So that's, again, one of the, at least at a conceptual level, a challenge to the law matters thesis, because what we see now is, a cross application of ideas, regardless of what the ultimate legal system is. So globalization has maybe in some ways changed our conventional way of thinking about the common law, civil law divide. And that's something for us to keep in mind as well. And which then brings me to my third and final point, which I'll complete within the next 3 to 5 minutes, given that I'm almost about to run out of time, is to just give you a quick snapshot about what's happening with corporate law in India. And this is something which is very fascinating, because like in many other jurisdictions around the world, corporate law started as a colonial experiment back in the 19th century. So there was a lot of transplantation of the then English company law into India, and many of this were verbatim transplants. So whenever there was a legislation in the UK, there would also be a change in India. So there was simply copying of legislation, which was understandable at that stage, because there was also interest groups that were involved, because a lot of times the investors happened to be British institutions or English institutions. And the idea was that these English investors wanted to ensure that the Indian law was similar to what the UK had, so that they can make their investments and they get very comfortable with what the legal system is. So there was no regard that was given to a lot of vernacular business forms. So for example, the Companies Act doesn't even talk about the Hindu undivided family, which was then a very important method of carrying on business, but that never found a mention because the company law was basically focused on what was happening in the UK at that time. But one of the arguments that I've also made in some of my writings is to argue that over a period of time, the reliance on the colonial power diminished, and that the umbilical cord was pretty much cut after India gained independence in 1947. And what we see after that is a story of divergence. So there was convergence in the beginning, and then subsequently we see what is happening in the last 20, 30, 40 years. And most importantly, with the most recent effort with the Companies Act of 2013, it's completely localized to meet Indian needs. No longer is there any reference to UK law or English law at all. There's been a complete disconnect from what is happening in the UK. So what we see is what I have called as autochthony or localization of the law, where despite the movement towards globalization, the corporate law, securities law, even the insolvency law, if you look at the insolvency and bankruptcy code, a lot of it has been localized, where the legislation considers local problems. The executive also looks at local implementation issues. And most importantly, the judiciary also looks at local issues. So in many of these areas of the law, except for a few exceptions, you hardly see the Indian court citing foreign decisions. So in that sense, you can be confident that the system of localization is pretty much complete, because if you look at the Indian cases in the 1960s, 70s, and 80s, there was a lot of citation to English judgments. But if you take any decisions that are occurring today in these areas of the law, except for matters like insider trading or maybe competition law, you would not see any citations to foreign decisions, or very, very minimal citations at all. So in that sense, maybe when you think about the Indian context, I think divergence has had a greater impact on the way the law has developed than has convergence. So that's something for us to keep in mind. But just to conclude with these 3 points, having looked at the global issues, the tools, having looked at the trends in Asia, and finally, very briefly, the issues on India, I would just like to conclude by saying that I think comparative law is a very fascinating area of the law. And I think this is what keeps comparative scholars like many of us in this group today going, because it's fascinating to study not just what's happening from a purely legal, technical perspective, but understanding the system, what goes behind the legal institutions, the culture, and all these have a role to play. And understanding these interplays is really fascinating. And thanks to the organizers for holding an entire conference on something so important. So thank you very much.
Thank you, sir. It was really correctly said that the fascination is to be continued, and where we are laying down the foundation, not only on the contractual terms, you have dealt a new dimension where comparison law is being dealt on corporate governance also. You started the journey for laying the foundation on the significant theories on the literature, and then you led the nexus also, which is required to make it clear how the law has a nexus with the comparison, which is making it vital significance us to go with the terms and the conditions. You have further laid emphasis on Indian Companies Act also of 2013. You laid down a certain provisions which are still not clear, but yes, we do have another provisions where we cover up with the allied provisions of the laws. And so the Supreme Court's judgments are also going into its own way. Thank you so much, sir, for this significant comparison which is drawn on corporate governance. Thank you so much, sir. Now I go on with the next keynote speaker, Dr. Subhajit Basu, who is FSRA, Associate Professor, Fellow ACCP, Editor-in-Chief. Sir is an Associate Professor of Information Technology Law, where he teaches and researches on the regulation of the Internet, including issues relating to privacy, data protection, freedom of expression, and also e-commerce. Sir was the chair of British and Irish Law Education Technology Association from 2018 to 2022. In 2020, he was awarded with the Hindu Ratna, a Hindi phrase which translates to English as Jewel of India, by the Non-Resident Indians Welfare Society of India, Government of India, for his outstanding contribution to education and achievements in the field of information technology law. He holds a PhD from Liverpool John Moores University and LLB from the University College of Law, Faculty of Law, Calcutta University. Sir has always aimed to explore the challenges that the internet has created in transforming everyone's lives, especially in the area of governance and in the legal framework, with a specific focus on Global South. Sir, I request you to address us. Sir?
Yeah, thank you. Thank you so much for the invitation, Professor Vinayak and Professor Matthew. Now, my lecture is going to be quite different from my two eminent speakers who spoke before me. I am a technology lawyer. I look at research into regulation of emerging technologies. I'm not a comparative lawyer. The lecture I'm going to give today is about artificial intelligence. So I've got interest into how artificial intelligence develops and how to create responsible artificial intelligence, particularly for Global South. Now, this research project, it's pretty much at the inception stage. And I've got colleagues from Nigeria and India working with me. I've got a colleague from IIT Delhi, who is going to look the technological side of this research project of creating responsible AI for Global South. It follows from my research on artificial intelligence related to autonomous vehicles and last mile robots, which was founded by Research Council in UK. Now, we read and we understand a lot about the discussion that is going on about development of responsible AI. But the aim of our project is to look at from a Global South point of view. We know AI can improve access to healthcare, personalized medicine, education, climate, agriculture, transport management, you name it, the list kind of goes on. But for the Global South, it offers even more promise to accelerate financial inclusion, possibly reduce gender and other intersectional inequalities. So AI can help us to achieve the sustainable development goals, UN Sustainable Development Goals. And overall, AI holds great promise for a more equitable, inclusive society. It possibly will be able to breach the developmental gaps between Global South and Global North. Now, if you look at any discussions about international governance of AI, you will see that mostly it has been taking place in North America, Europe, and some Asian countries. What is clear, by the way, I'm defining Global South in a very generalized manner. I'm not very specifically identifying countries which would fall because, as Professor Wagner was showing, Singapore, Hong Kong would not fall within Global South by any stretch of imagination. Global South in general is underrepresented. Many countries in Africa, Latin America, and Caribbean are entirely absent in this vital conversation. The question is, so what is really at stake? Now, there is a widening gap in prosperity and wealth around in the developing countries. But with bringing of AI, it would be unable to develop the digital skill and infrastructure, which would have happened if AI had been developed or is going to be developed in ways that could give benefits and create opportunities that I was just mentioning at the beginning of my lecture for the Global South. We have also to understand that the development of AI is not without risk. AI can produce unintended negative consequences. There are inherent design flaws that can cause exclusion, discrimination, and inequality. If bias creeps in while training the data set, the outcome will always be always suffer from biases. And AI has a capacity to create a total surveillance society, which can undermine the democratic process, as we had seen with the involvement of Cambridge Analytica and Facebook. But for the global South, AI can bring much more damage. AI can widen the digital and inequality gaps between countries and within societies. Now, I'm going to tell you some certain terms which you have come across, which you probably know. Terms like AI colonialism, data capitalism, technology imperialism. Now, these are emerging terms in emerging terminologies that describes the global North's dominance and ownership of AI and data. These terms capture the power asymmetry between the global North and the global South, particularly in relation to artificial intelligence. There are other areas I'm just focusing on artificial intelligence for the moment, for the purpose of this lecture. It highlights the inequality and exclusion of global South from the design, development, and AI governance initiatives. Interestingly, AI doesn't get designed in global South, but experimentations on AI for the purpose of developing the algorithms actually happens in global South. So most of the significant challenges of AI is definitely how to develop the governance framework that will enable AI to fulfill its potential while also address the most pressing challenges. The notion of responsible AI that has dominated the policy debates on AI governance in this regard has happened in the global North. Now, if you look at the definition of responsible AI, you will see it says that it encompasses the positive elements like fairness, inclusion, transparency, explainability, accountability, safety, respect for human rights. The question is, are they only relevant for the global North? And the other question is, are they only relevant for the global North in their terms? The responsible AI needs to be embedded for any discussion on emerging ethical policy and legal framework. Council of Europe has proposed a convention on AI, human rights and democracy and rule of law. It's a proposal. It probably will happen. On the other hand, European Union has proposed a new AI Act, which is undergoing consultation among the member states. As of 2020, April 2020, there are around 173 ethical AI guidelines, either developed by big techs or they're developed by social media companies or other tech companies and platforms. The critical challenge is that governments, regional and supranational institutions, and tech companies in global North, they are mainly responsible for developing this emerging governance framework. They are responsible for developing this policy frameworks or even technological frameworks. When we regulate technology, we do not just regulate with law, we regulate with technology. So it's a regulatory framework, which is a combination of legislation and technology. So law creates the control, technology enforces it. Some countries in global South are actually thinking about developing, or they are in the process of developing domestic legislation promoting data localization and data sovereignty. India's data protection bill, personal data protection bill, is at the moment going through the parliament after quite a few years of hither and thither. However, what has not been clear, and by the way, we are at the very start of this research project, is whether this data policies will ever become part of AI governance strategy of these countries. We all kind of know historically, global policymaking has always been constructed and reconstructed by the norms of Western developed countries. But the world has changed, and it has changed even more in the last 3 years. But our problems have changed. On the other hand, AI isn't anything we have ever seen before. Marginalization of global South from AI governance initiatives should not happen. like it happened in other areas, particularly at the development of information society, until the point when UN stepped in with the WSIS summit. The participation of the global north, and at that time it wasn't actually, participation of global south, and at that time it was not called as global south. It would be all like third world country or developing countries, didn't really happen. It was dominated by US. Of course, it started in US and Europe. For example, if you just really kind of think in this way, Europe has taken a leading role in global technology governance. Nothing wrong with it. It's fine. Somebody do have to take a leading role. Take the example of GDPR. It's an outstanding example of data protection law, data protection being an European project. Makes sense. But Europe has never been empathetic or cooperative in its approach to lawmaking, has never been. Instead, what Europe does, it depends on the Brussels effect to carry through its legislative agenda. And for this reason, if you look at the African countries, they disproportionately affected by GDPR, either because limited participation of African companies or mostly African companies in the global market, or because of the GDPR, how it has been enacted, how its extraterritorial reach is, that this particular law completely shuts out African companies out of the global market, out of the European market, because they are not able to meet with the GDPR standards. Which takes me to my other research, which I've done on privacy and data protection. Is GDPR the global standard? Should it be the global standard? Unlike GDPR, if you look at the new AI regulation by the European Commission, the European Commission is again relying on the Brussels effect to achieve the global compliance. Council of Europe will depend on the convention status and best practices model to persuade non-party states to adopt its proposed AI convention. On the other hand, the big takes, they will enforce the so-called ethical norms of global north on the rest of the world by using their market share and power. This means this whole approach to AI governance will provide economic prosperity and well-being for the wealthier economics in the global north. It's a different question whether the Europe does have the wealth it thought it would have, or it thinks it had. At least the cost of living crisis that we are going through in UK at the moment doesn't feel that we are part of a wealthier economies anymore. Now, that's a different thing. The question is, then this development of the policies and the regulatory framework, it will protect the rights of citizens in the global north and downplay negative impacts of technology in the global south, with its rhetoric that it has a transformative power. But for whom? Exactly, that is the point, for whom? It can be also argued that this is nothing but subordination of the global south in AI policymaking and governance. This seemingly internationalization of frameworks offers no respite, as AI is ultimately about power and resource control, and the so-called international agendas are unlikely to benefit the global actors equally. Not surprisingly, as I said before, global south countries are adopting data sovereignty strategy. It's kind of a countering to this global north narrative that we know best what is good for you. And this kind of ensures managing informations in a way that is consistent with the practices and the customs of states, nationalities, and communities. And Professor Vartoli was talking about, since independence, India has moved on from not following the UK tradition of following the company law. It's pretty much independent. I still remember in a different life when I was practicing Calcutta High Court, we used to, because Calcutta High Court has got the highest number of barristers, we used to regularly refer to UK cases. I don't think that happens anymore. I hope it doesn't happen anymore. Now, there is a growing trend in Africa and India. India also wants the same, for example, to include data localization to restrict data use, data storage, and data processing to be given to another country or region. At least India wants for a copy of the data to be kept within the jurisdiction of India that raised this whole discussion about digital sovereignty or sovereignty in cyberspace. But the problem with that is that as a governance strategy, it also creates problem. While data sovereignty and data localization initiatives might give states some control over their data, it also creates disadvantages when it comes to investment, when it comes to restricted access to data. And this could, at least in theory, increase compliance cost for small firms and AI startups, thus making them less viable, less competitive globally. Apart from the big techs, they are not major players in the world at the moment. I have one of my good colleagues, Professor Pina Rahman, who's an expert in competition law, and she has been arguing that although this big techs technically looks like a monopolistic company, but they are not really monopolistic company because they still give benefits to the consumers, to the customers. I'm not sure how, but that is an argument. Now, the very promise that AI will ensure power redistribution through accessible and equitable innovation and responsible governance does not and probably will not hold true, because the possibility of AI colonialism would undermine whatever gains we have managed to make since post-colonial self-determination and state sovereignty. We are in 2023, we're still going back to find out where did a country's law actually originated. We still are not in a point, we are saying that, look, these countries, although maybe have originated from a different theoretical background, from different countries' principles, but it has created its own way of interpreting it to the point that it doesn't really has got any connection, which Professor Bertoli was also telling about to its mother. Now, it can create the horrors of colonial exploitation and extractivism, and increasing the fear that developing economies will benefit only marginally from the governance structures. On the other hand, data sovereignty is also unhelpful in fostering responsible AI governance. According to United Nations, an inclusive governance framework which intends to seek frontier technologies like artificial intelligence should be developed for global good, and it should be done in a way by rethinking the existing approaches to governance and policy making. Now, UN is very good when it comes to rhetoric, but it is very bad when it actually comes to delivering it. Now, the policy must address not only the technological challenges of design and development, but also the implications of AI for societies, individual rights, and it needs to safeguard the shared values of democracies and human rights. Global South is not a homogeneous combination. It's not all countries in Global South adheres to democracy. So there again is a problem, shared values. How do you define what is a shared value? And how do you define whose values has a precedence over the other country's value? But one thing is certain, it must involve international multi-stakeholder cooperation. However, despite the growing interest and debates happening in this area, there needs to be more comprehensive research, and this is where we come in. We want to do the research in this area, and we've got some money, and we are hoping we'll get some more money. That's a vested interest. But for example, there is not really a lack of clarity about how international agendas on AI governance will promote values of the Global South, which is not a homogeneous thing, but it's also unclear how to chart the course of a truly inclusive AI governance. Also, while AI colonialism and associated concepts like data capitalism, technology imperialism, data sovereignty have gained importance, but they have not been extensively researched. It's not important. If you look at the research that is happening in Ada Love Law Institute or Alan Turing Institute, it's very, very focused on the global north. One thing I can say clearly that regulating AI is a complex topic, and there are diverse views regarding what degree and what form of regulation will be effective for various applications. AI is a rapidly advancing technology, and one size fits all approach will not be the most suitable approach and will not definitely work. Finally, I want to conclude by saying that at global level, AI governance is far from ideal. And one of the reasons is because one of the reasons for it is when it comes to regulation of technology, when it comes to development of technology, when it comes to conception of technology, there is this privileged assumption in the global north that global north understands what global south wants or needs. Interestingly, I was the chair of BILITA for 4 years, and I completed my term, and I was reading some of the abstracts just yesterday evening after my work, and I saw a comment from one of the reviewers about an abstract. He or she, whoever read that abstract, rejected that abstract. It was very interesting. The comment was, the abstract was submitted on Kingdom of Saudi Arabia's copyright law and how the country wants to regulate it and everything. And the reviewer commented that if this abstract was based on freedom of speech and expression rather than intellectual property, that would have made the abstract far more interesting. And that is so fascinating and so colonial, and to the point is so racist, that is it because that it is Kingdom of Saudi Arabia that it cannot have a problem on intellectual property, but it can have a problem on freedom of speech and expression? Why is that? Why is that thinking? That is my question. Why is an Indian user or an Indian legislator less capable than anyone else in the global north? What is the proof of it? Yes, we have a constitution which we created, taking things from all different constitutions. Longest constitution in the world has gone through n number of amendments since then. But India is a young democracy. It has to go through. Doesn't mean India creates any more bad laws than any other countries in the global north. Just look at the data retention laws in Europe. It was thrown out of European Human Rights Code number of times because it's not compatible with European Human Rights Convention. So it's not like India or the global south only are responsible creating bad laws. Global north does the same. So the thinking is part of the problem, because this thinking has created mistrust towards multilateralism. It created geopolitical tensions and unhealthy competitions. Since India's independence, India has been a strong advocate of multilateralism and reformed multilateralism. So now is the time for India is to show a leadership, to develop a South-South cooperation. A decentralized, a fragmented AI landscape is not going to help anyone, which has become kind of a norm. So we need to develop comprehensive governance tools such as normative instruments, institutions, and technical standards and safety measures that takes into account the needs, aspirations, and the thinking of global south as much as global north. And there are numerous initiatives at national and regional levels, but by private sector and civil society, but they are happening at the exclusion of the global south. Global south is pretty much sitting on the sidelines, which I think needs to change. Thank you. That was all I had to say. I hope it wasn't too gloomy.
Certainly not. It was really enriching experience for all of us, sir. Thank you so much, Basu, sir. You began our journey with information technology. Certainly, you have created another mark on artificial intelligence, creating and searching for the responsive one as AI. We have also understood that this has an access to improve, accelerate financial, even sustainable development goals. Development of artificial intelligence is to understand that it involves risk also. Your specific emphasis on the terms colonialism, data capitalism, which has certainly highlighted us also to have the questions and answers to figure out on ethical, legal governance provisions for AI. Your specific further emphasis on human rights, democracy, and rule of law has led us to know why we have to go more about the AI as its challenges also assures to be more responsive through formation as technology and as for regulatory also. As you have greatly mentioned upon the power of the global south also, the country. So what should be our address as perception? Should it be taken as subordinate, which is need to be further explored, or the data sovereign, which is required to be addressed as a key concern to safeguard the values of democracy? Thank you really, sir. It was really enriching experience laying the foundation from contract to corporate. Now we got the artificial intelligence also. Thank you, sir. Now, beginning with another keynote address of Mr. Ranveer Kumar Singh, who is the director of Uni Legal LLC, Singapore. Now, from academia to adjudication, sir has been dealing the matters of accident and personal injury claims, admiralty, shipping law, arbitration, banking, finance, and securities law, bankruptcy and insolvency law, civil and commercial litigation, conveyancing and property law, corporate and commercial law, employment law, family law, insurance law, intellectual property law, landlord and tenant law, mediation, wills, probate and administration of estate, workers' compensation claims for adjudication. Certainly, sir, with your practical insights of how the claims have to be addressed for all the aspects where the reliefs can be sought, your presence is really appreciable for us. Sir, over to you.
Thank you very much, Suparnaji. Very good afternoon to everyone. I would really like to thank MIT University for inviting me as a keynote speaker to this event, which is your 4th International Conference on Comparative Law. And this is the 4th year in the running for me to be with you. I'm really glad to be seeing you all again, be present among such a distinguished audience. My topic for today is the 4th International Conference on Comparative, basically developments in international commercial mediation from the Singapore perspective. Now, if I may start with giving you a sketch, a brief background of the international mediation scene in Singapore. Mediation has increasingly been used over the last 10 to 15 years as a mode of resolving disputes on generally all kinds of disputes, but more recently, also international commercial disputes, because of the advantages which mediation provides as a mode of dispute resolution. I take it you're quite familiar with mediation. If some of you who are not, I'll just give you a bit short description of what it involves. Basically, what it involves is the two disputing parties presenting the case before one or more third parties, who is called a mediator, for the mediator to help them to resolve the dispute. Now, to that extent, it is quite similar to arbitration. Where it departs from arbitration is, unlike in an arbitration where the arbitrator adjudicates on the dispute and makes a finding and makes an award, a mediator does not adjudicate on the dispute. And that's a significant, important difference. The mediator helps the parties to negotiate the disputes and come to a negotiated settlement. When the parties reach a settlement, then the mediator will help them to sign a settlement agreement. And that agreement becomes the new contract between the parties. Now, one of the key benefits of mediation is that it is a very quick and time-saving process. It is quick because all you have to do is to present your dispute to the mediator. You need not bring in witnesses. In most cases, no witnesses have to give any evidence. There's no evidence taking before a mediation. And you can call for mediation anytime a dispute arises. You don't have to wait to file pleadings and file court documents and so on. You don't have to do that. All you have to give is to provide a brief summary of the case to the mediator. And in most cases, the dispute is resolved within 1 day. In some cases, 2 days. So you can imagine it's a very powerful tool to resolve disputes with a considerable saving of time and, of course, costs for all the parties. However, there's some disadvantages in mediation. That is, when the settlement agreements are concluded after a successful mediation, then when it comes to enforcement, of the settlement agreement, therein lies the problem, especially in an international setting. In a domestic setting, the settlement agreement can be enforced quite easily in the courts. But in the international setting, there is no equivalent body. Unlike in an arbitration, where we have the New York Convention, which provides for the enforcement of arbitral awards. In the mediation sector, we did not have this until quite recently. So, in order to address that disadvantage, in other words, of the enforcement of an international settlement of an international mediation dispute, the UNCITRAL took some steps in 2018 to finalize what we call the United Nations Convention on International Settlement Agreements Resulting from Mediation. That was adopted by the United Nations General Assembly in December 2020, and that convention is now known as the Singapore Convention on Mediation, or in short, the Singapore Convention. In August 2019, the Singapore hosted the Singapore Convention signing ceremony and conference. On that day alone, 46 countries signed the convention. One of those countries was India. And of course, Singapore was also the other country, being the host country of the convention. In September 2020, the Singapore Convention came into force in Singapore. And the process of enforcement has been made quite easy and straightforward. As of 5th February 2023, when I checked, the Singapore Convention has 55 signatories, out of which 8 are parties to the convention. Singapore, in moving forward with international mediation, Singapore has established the Singapore International Mediation Center. This center works quite closely with the Singapore International Arbitration Center. So SIMC, which is the Singapore International Mediation Center, it is an independent, not-for-profit organization. It works across multiple jurisdictions. It has panels of mediators from all over the world, and these mediators are able to cover both the common law and the civil law traditions. So SIMC provides a very effective dispute resolution mechanism through its professional case management and through its assistance to the parties in carrying on with their mediation, as well as in the enforcement part of the mediation, helping them to assist in providing authentication of the settlement agreements. So that's by way of a brief sketch of the international mediation scene in Singapore, insofar as international mediation is concerned. Now, let me touch on some of the key features of the Singapore Convention. The Convention is a multilateral treaty. It applies to mediated settlement agreements on international commercial disputes, which result from mediation and which are concluded by parties in resolving the commercial dispute. So, it also provides a uniform and efficient framework for the enforcement and invocation of international settlement agreements resulting from mediation. Now, what that means is, insofar as enforcement is concerned, the provisions provide for a very easy way of making the enforcement. A party to the settlement agreement can always bring the settlement agreement to the country which is signatory and get an order from the national court to convert the agreement into a domestic court order. And as a result of that, it can always enforce the settlement agreement as if it was a domestic court order. The other point is about invocation of the agreement. So what it means is, if there was a dispute in any national court, the signed settlement agreement can be used as a defense. For example, it is relevant to that particular dispute in that court. So the settlement agreement is binding and enforceable in any country which ratifies that treaty. It is the experience of the authorities, businessmen, lawyers, and the government that the convention does facilitate international trade and commerce. It enables disputing parties to easily and enforce and invoke settlement agreements across borders. Businesses therefore benefit from the mediation, as I explained. This is a very quick and time and cost-saving mode of dispute settlement as an option to litigation and arbitration in settling commercial disputes. Now, I must touch on something where the Singapore Convention does not apply. It does not apply, one, to international agreements which are concluded during judicial or arbitral proceedings. And the reason for that is, for those kind of settlement agreements, there are different mechanisms which provide for how they should be enforced. Secondly, settlement agreements concluded for personal, family, or household purposes by one of the parties, i.e. a consumer, as well as settlement agreements relating to family, inheritance, or employment law. Those are very domestic matters. They are handled by domestic courts in their own respective, under their own respective domestic laws. So they do not form part of the international commercial settlement, which is really confined to commercial disputes of an international nature. So that's the restriction of the Singapore Convention. Now, let me touch on a little on the enforcement under the Singapore Convention regime. As I explained earlier, the national courts of any contracting party can handle the applications for enforcement of the settlement agreement, which falls within the scope of the Singapore Convention. It's quite easy. What all the parties have to do is to produce the settlement agreement and also evidence that the settlement agreement arose from a mediation and not from anything else. And for that purpose, they could get the agreement signed by the mediator who conducted the mediation, or an authenticated document from the institution which processed the mediation. For example, the Singapore International Mediation Center. However, the national courts may refuse to grant relief in terms of enforcement on grounds which are laid out in the convention, and that includes a number of factors. One, if a party to the settlement agreement was under incapacity. Two, if the settlement agreement is not binding, null and void, inoperative, or incapable of being performed under the law it is subjected to. Three, if there was a serious breach by the conciliator of standards applicable to the conciliator. For example, if the mediator did not declare of any potential conflicts of interest or actual conflicts of interest, which means that has an impact on his impartiality and independence, that can be a ground for not granting relief. And finally, if granting the relief would be contrary to the public policy of the contracting party. So these are the grounds which are set out in the convention itself. The national countries may add on to these grounds. It all depends on the statute which brings into force the treaty. So that's something to be looked at. So you will see that these grounds are quite similar grounds upon which national court will not grant relief or enforcement even for an arbitration award. So they're quite similar. Let me touch on some steps that Singapore has taken to enhance international commercial mediation. Our experience has been that mediation has assisted in resolving a wide range of disputes, including large, complex, and high-value claims. In fact, the scene in Singapore is that every case that is filed in the court will have to go through a mediation process. Only if the mediation doesn't result in a settlement will the case then progress to trial. Our experience has been that about 70% of the cases filed in court are resolved well before trial because of mediation. Now, similarly, we have got certain schemes which I will deal with just in a moment, how mediation are also being applied to disputes in the Singapore International Commercial Court and Singapore International Arbitration Center. Going back to mediation, the impact of it, In 2021, the total value of claims filed with the Singapore International Mediation Center was US $3 billion, which equaled the total value of claims filed in the preceding 6 years, i.e. from 2014 to 2020. Last year alone, the value of the claims rose to 4.84 billion, i.e. an increase by 1.84 billion over a one-year period. Secondly, Singapore has now allows a party to an international commercial dispute to obtain funds from qualifying third-party funders to finance all or part of the cost of the party in the dispute. Earlier on, a third party was not able to fund the cost of mediation or arbitration because of the common law rule against maintenance and champerty. Singapore has taken statutory measures to abolish that tort insofar as it involves certain kinds of claims, one of which is international commercial mediation. So third-party funders are allowed to fund parties for the purpose of the claim. Otherwise, some of these claims may not see the light of the day. Parties will not be able to afford to file the claims for mediation or arbitration. So that was the reason why, to improve access to justice, statutory amendments have been made to the Civil Law Act to allow third-party funders to finance the claims or defense of a party. Another development has been Singapore allows foreign mediators to mediate in international commercial mediation. In other words, even lawyers who are not called to the Singapore bar, they are allowed to represent parties where the mediation is of an international commercial in nature. And that allows for parties who have no real connection with Singapore to use Singapore as a host for resolving the disputes through mediation. So the mediator could be a foreign party. The lawyers representing the parties could be foreign lawyers. That is now permissible in Singapore. Now, a further development more recently, in fact, just last month, in January 2023, is that there's a mediation protocol, which has been enforced, and this is due to collaboration between the International Mediation Center and the Singapore International Commercial Court to promote amicable resolution through international commercial disputes. And what it means is, every case that is filed in the Singapore International Commercial Court, which is inevitably involves international in nature, before that case goes to trial, parties are given the option to go for mediation first. If they go for mediation, then there'll be a stay of the proceedings, and a mediation will be held within 8 weeks. If the matter is settled, then the settlement agreement can form part of the court order of the Singapore International Commercial Court. If the matter is not settled, then it will proceed in the normal way to a trial before the court. So this is another way to help parties to save time and cost to resolve the international commercial disputes. Similarly, earlier we had similar protocol with the Singapore International Arbitration Center, and the process is the same. What it means is, if a case is filed in the Singapore International Arbitration Court, before it goes for full hearing before the tribunal, parties are given the option to go for mediation. And similarly, if they do agree, then the mediation will be held in 8 weeks. If the matter is settled, it becomes part of the arbitral tribunal's award. If it's not settled, it'll go for full hearing. So, in conclusion, mediation in Singapore is playing a very, very important part as a mode of dispute resolution. It is definitely here to stay and grow. It is being aligned and working closely with the other modes of dispute resolution, i.e. court, action, and arbitration. So these three modes will be tied together, working hand in hand, and with the hope that the disputes can be resolved quickly, saving in time and cost for everyone. On that note, I conclude my presentation. I'd like to thank you very much for your kind attention. Thank you.
Thank you so much, sir. Really, you have let us know from the litigation to the mediation. You began with the concept from defining to its procedure for resolving the disputes. Beginning of a lawyer's professional ethics is seriously towards the justice. And so you did in making us clear with the concept of the mediation. You further emphasis on the stage of mediation procedure as expedite one. You let us know that how it is time saving and it is cost saving. Rather than relinquishing the rights for its enforcement, the further remedies can be sought, and you made it clear with your speech, sir. And the genesis of the mediation began from the UNICITRAL and to the Singapore Convention. You have rightly demarcated the same. So India has its procedure. If a case is filed in the Indian Code, Section 89 of Code of Civil Procedure 1908, sir, also facilitates the mediation. And certainly the lawyer aim is to let the party get the justice, and that party is an aggrieved party. So the process is always there to facilitate how things can be more expedited. Thank you so much, sir. I begin with now Professor Paul T. Barbie, who is also here with us, Bonneton Chair in Law and Professor, Adelaide Law School, the University of Adelaide, Australia. Sir is an expert in property law, theory, and its theology. His research throughout his career has asked what property is and how, if at all, it can be justified. Sir considers those questions from legal, theoretical, and from theological perspectives. Sir's approach towards property theory law involves the exploration of its special dimension. Sir has taught property law and in different aspects, the law, religion, and the Roman law. Sir has joined the Adelaide Law School in 1999 and was promoted to a personal chair in law in 2015 and was named the holder of Bonneton Chair in Law in 2021. Established in 1926 by a gift of Sir John Langton Bonneton, KCMG, the Bonneton Chair in Law is the first endowed chair of the Law of University of Adelaide. Sir is only its 9th holder in the 140-year history of Adelaide Law School. Sir is currently Associate Dean of Law, International Development, and Director of the Research Unit for the Study of Society, Ethics, and Law, and has previously been Associate Dean of Law Research and Associate Dean of Law Learning and Teaching. He was elected a Fellow of the Australian Academy of Law in 2017. Sir, I welcome you here, and I request you to please address us.
Thank you very much for that very warm and full introduction. I'm delighted to join you. It's just gone about 20 minutes to 9 p.m. here in Adelaide. As I say, I'm very happy to join you. I'm going to be speaking to you tonight briefly about one of my research areas, which wasn't one of the ones that was introduced. It was sort of partially introduced, but law and religion. I'm going to say a little bit about that tonight in relation to some work that I've just completed and that I'm continuing to work on, and that relates to the Australian Constitution. And what I want to tell you about the Australian Constitution is it always surprises colleagues from other jurisdictions when I speak to them that the Australian Constitution, or that Australia generally, is one of the last, or is the only, I should say, Western liberal democracy that does not have a comprehensive constitutional Bill of Rights, nor does it have any comprehensive legislative protection of human rights. Whatever human rights protections do exist in Australia are found scattered through the Australian Constitution itself. So there are 5 different rights that are found in different parts of the Constitution, and there are various anti-discrimination statutes or pieces of legislation, which exist at both the federal and the state level. Australia being, of course, a federal democracy. So there's a federal jurisdiction and a state and territory jurisdiction. So there is no comprehensive rights protection, as I say, in the Constitution. And as I've also said, there are some rights which are scattered through the Australian Constitution. One of those rights, or collection of rights, is found in section 116 of the Australian Constitution, and that is what, just for in shorthand, can be called the religious freedom protection of the Constitution. And it contains 4 different guarantees, but the 2 most important guarantees are an establishment clause similar to that which is found in the US Constitution. So it prevents the establishment of a state religion. But also, more importantly, for what I want to say to you tonight, there is a free exercise or religious freedom protection in section 116. Now, that section, when people, if you read the section, and I won't read it out to you, and I'm not going to put it up on screen, but what I want to tell you is simply that when you look at it, people that are familiar with the US Constitution will say that that sounds very much like the First Amendment to the US Constitution. And in fact, when people say that, they're quite right, because the framers of the Australian Constitution, who were working in the late 1800s, so about 1892 to 1900, were very familiar with the American constitutional experience, and indeed adopted many of the principles that are found in the American Constitution, both in the Constitution itself and in the first 10 amendments to the Constitution, which of course have become known as the Bill of Rights. So many of the Australian framers were aware of that American constitutional experience, and so therefore transported or transplanted some of the language, and in some cases almost verbatim, across into the Australian Constitution. And that is certainly the case for section 116 of the Australian Constitution. It seems very similar in its language. However, over the course of the little more than 100 years, about 120 years now of Australian Federation, the High Court of Australia has very narrowly interpreted section 116, and in particular, the protection for free exercise or freedom of religion. So unlike the First Amendment to the US Constitution, which has been very expansively, as most people will know, has been very expansively interpreted, is in fact is being more expansively interpreted by the current US Supreme Court. The Australian High Court, which is the functional equivalent of the US Supreme Court, has gone in the opposite direction in the last 120 years and has narrowly interpreted section 116. And in fact, the position that now pertains is that section 116 is seen as purely a limitation on legislative power and not as a protection of fundamental rights. And what that really means is that unless the federal government, and this is another problem with section 116, it only applies to the federal government as opposed to the states. It's now taken to be the case, based upon High Court interpretation, that only if a piece of legislation expressly has the purpose of restricting religious freedom will that legislation be taken to violate section 116 of the Constitution. So it's not about the effect of legislation, and as we know, in many instances, the infringement of fundamental rights comes about as a result of the effect of legislation in its operation as opposed to its express purpose. But in Australia, for the purposes of section 116, only if a piece of legislation takes as its express purpose the limitation of free exercise will be taken to violate section 116. So this leaves us with, as I say, a very narrow interpretation of that provision. And this is already on top of the fact that there are very few fundamental rights protections, either constitutionally or legislatively, in Australia. So that raises the question then, how is it that free exercise may be protected if one wanted to protect it constitutionally in Australia? And that brings us to another right, which is found in the Australian Constitution. But when I say that it's found in the Australian Constitution, I'm not actually putting it correctly, because what that right is, it's called the implied freedom of political communication. So political communication is free and protected. So we might all say that we more or less understand what that means. Again, the US Constitution, the First Amendment protects freedom of speech. But notice that I have included the word implied freedom of political communication. And what that means is that nowhere in the text of the Australian Constitution is there a protection for political communication. Instead, the High Court, beginning in a line of cases in 1992, took the Australian Constitution as a whole to have established a democratic system of government. And what the High Court then inferred from that is that if there was a democratic system of government established by the Constitution as a whole, then what that must mean is that in order for a democracy to operate, it is important that there be freedom of political communication. And so therefore, there must be implied from the text of the Constitution as a whole, freedom of political communication. So this is a very significant right which has been added in a sense. It's not part of the text of the Constitution itself, but it is now taken as part of the panoply, limited as it is, of constitutional rights protections in Australia. So added to those express rights, which are scattered through the Constitution, including Section 116 and free exercise, is now this implied freedom of political communication. Now, the important thing to know also about the implied freedom of political communication is that it applies because the Constitution as a whole sets up the democratic system of government in Australia for both the federal and the state level of government. The implied freedom is taken to be a right which protects against infringements of political expression at both the federal and the state level. So remember a moment ago, I said Section 116 is taken only to apply to the federal government. The implied freedom of political communication is taken to apply to both the federal and the state government. So very significant extension of that right beyond the federal level of government. Now, the reason that all of this is interesting and important to me is because there is a continuum that exists between, at one end of the continuum, conscience. So someone's freedom of conscience, freedom to believe or not to believe as they so choose. And moving along that continuum towards the other end of the continuum is conduct, right? And so when you move from conscience, you have a religious belief. At some point you cross into where that belief then must be manifested through some form of conduct. And the most obvious forms of conduct in which conscience manifests itself is worship, freedom to worship according to one's beliefs, and in some instances, the freedom to protest according to what is required by one's religious beliefs. So the question that arises then in relation to the implied freedom of political communication is, does that freedom, that right, firstly, apply to religious expression? And secondly, if it does apply to religious expression, and even if it doesn't apply to religious expression, can that right also apply to language, speech, which is combined with conduct? And in the US constitutional experience, there is a doctrine known as the expressive conduct doctrine, which means that you have a mixture of speech and conduct, and that is protected through the sort of convergence, if you will, of the First Amendment protections for free exercise and free speech. So the question then arises, can there be a doctrine of expressive conduct within the Australian implied freedom of political communication? So this is very significant, because if you think about one of the biggest reasons why this becomes important is what we've just seen globally, the COVID-19 pandemic, and that in various jurisdictions, Australia, India, the United States, Canada, where I'm from originally, all of those jurisdictions placed restrictions on gathering for the purposes of religious ritual worship and so forth, right? So there were restrictions placed upon that. And the question that arose in many jurisdictions was, well, is that actually an infringement not only of free exercise or free, free exercise, but also of free speech through this idea of an expressive conduct doctrine. But it's even more important in Australia, because the reason it's more important in Australia is because of the narrow interpretation of Section 116. 116 hardly can protect free exercise. And so the question of whether or not there can be a doctrine of expressive conduct within the implied freedom would radically open out the protection for free exercise if you were to say that there's this doctrine of expressive conduct and it may include religious speech as part of that expressive conduct. So the question then, is it protected? There's no answer to that question, right? Because we are still working our way through, because the right is continuously being interpreted and reinterpreted by the High Court of Australia every year. There are a number of cases every year that are being dealt with by the High Court of Australia on the implied freedom. So we don't have an answer to that question yet. But what I have been doing with my colleagues, particularly Professor Arvind Banu at Amity, and Gianluca Sterling, who's a colleague of mine, a practicing lawyer here in Adelaide, we've been looking at the constitutions of Australia, the United States, and India to determine to what extent the doctrine of expressive conduct exists in the US First Amendment jurisprudence and in the Indian Constitution in relation to Articles 25 to 28 and 19 of the Indian Constitution. And indeed, there is a doctrine of expressive conduct. It might not be called that, but there is certainly a doctrine that can protect expressive conduct in both of those constitutions. So it definitely exists there. And what we have been trying to do is to say, look, if we look at these other constitutional enactments and take a purposive approach to what those enactments are trying to do, then we can adopt some of that interpretation and apply that to the Australian context, and in particular, the implied freedom of political communication, to say that there may be actually scope for a doctrine of expressive conduct within that right as well. Now, even if we can decide that expressive conduct is protected within the Australian Constitution and the implied freedom of political communication, as it is protected in the United States and India, there may still be instances in which that freedom, even if there is a freedom of expressive conduct, may be limited by the state for legitimate state objectives. In other words, the community interest may need to take priority to the individual or even the collective freedom of association involved in expressive conduct, particularly in communal worship, for instance. There may be instances in which the community interest must take priority. So there's a balancing that has to occur there between the individual right in relation to expressive conduct and the community interest. And again, the best example of that and the most obvious example is the COVID-19 pandemic. In many instances, on our analysis, what governments around the world did would be a legitimate limitation placed upon expressive conduct of a religious nature, notwithstanding the fact that that is a fundamental freedom. So the very fact that you have a fundamental freedom does not mean that it is absolute. We know that very well from our understanding of the US and the Indian jurisprudence. What's interesting about those two models is that they provide different models of how we might go about that balancing process between the individual right and the community interest. The American model, of course, we've got a textual protection for free exercise and free speech, but there's no limitation clause that is found expressly anywhere within the Bill of Rights. So what has happened is that the US Supreme Court has judicially created through the doctrine of strict scrutiny, and there's also many other techniques, in fact, that the US Supreme Court has adopted in relation to balancing the individual and the community interest in relation to fundamental rights violations. But the point is that all of those have been judicially created, right? So that's one model that you can look at in a comparative sense as to say, well, we've got the right is protected, the right may have been infringed, But now we need to decide whether or not we can balance that infringement against the right itself to decide whether or not the infringement is justifiable. The other model, of course, is the Indian Constitution, and that is not only is the right itself expressly found in the Indian Constitution in the text of sections 25 to 28 or Article 25 to 28, I should say, in Article 19, but also the limitation clause is also found in the express text of the Constitution. So those are two models. And again, as I said earlier, this is something I'm working on with my colleagues, Arvind Banu and Nico Sterling. And we've looked at those two models and tried to say, how can we use those models to provide guidance to the way in which the High Court of Australia may balance the implied freedom of political communication against the community interest. And in fact, the High Court of Australia, as you might imagine, in the first sort of period of development of the implied freedom of political communication, was very much concerned with sorting out what was the nature and the ambit of the right itself. And in the subsequent stage of the development of that right, which we are still in, so I would say from about 1992 to about 2000 is the first stage of that development. And then starting from about 2000, in particular 2004, up until now, we're in the second stage, and that stage is still ongoing. And that is the stage during which the High Court has specifically started to map out the limitation clause or the approach to balancing that it will use. But all of that, of course, as you would expect and imagine, because it is implied, has been judicially crafted. So because it is being judicially crafted, the High Court is very much looking to models found in other jurisdictions to how that balancing may be done. Now, why is all of that of practical importance? Why is the comparative approach of practical importance for us here in Australia in relation to the implied freedom of political communication? And the practical importance comes down really to 2 points. First, in fact, the High Court of Australia deals with about 35 to 40 cases a year. And over the last several years, about 3 or 4 of those cases, so about 8 or 9% of the entire docket of the High Court of Australia, are implied freedom of political communication cases. In fact, it is the most common constitutional case now that comes before the High Court over the last, I'd say, 5 to 6 years, right? So it is, in fact, becoming increasingly important, this right, as new litigants in all sorts of fields of endeavor, not just in relation to religious free exercise, but in various fields of endeavor, as litigants are starting to think to themselves, this is a possibility for some rights protection here that doesn't otherwise exist in the Constitution. They are turning to the implied freedom to see what possible scope that right might have. And the second reason that this is important is there is, in fact, a pending case now before the New South Wales Supreme Court, which is a trial level court, but the case will almost certainly go to the High Court eventually. So it will go through the New South Wales Supreme Court, then to the Court of Appeal, and then it would go to the High Court after that. And that is a pending challenge to new laws, which were just enacted last year, which are anti-protest laws. Okay, so this now specifically brings together the point that I've been making, and that is you've got the implied freedom of political communication, but can it also protect expressive conduct? And you recall earlier, I talked about the idea of protest. That is the clearest example, other than worship, where expressive conduct becomes relevant. So there is a challenge currently pending before the New South Wales Supreme Court, challenging these new anti-protest laws by environmental activists, right? So it's nothing to do with religious worship. This is entirely to do with environmental activism. And their argument is dependent upon the concept of expressive conduct. And so they will very much be looking to the models that are found in other jurisdictions, most notably jurisdictions like the United States, India, and Canada as well. I didn't talk about Canada tonight, but certainly that is one of the jurisdictions that the courts will be looking to. So that's the importance of comparative law for the Australian Constitution, and in particular, the implied freedom of political communication. So thanks very much. It's been great talking to you, and I wish the conference great success.
Thank you so much, sir, for the best wishes, I will say rather. You have dealt it exhaustively by going with the comparison on US, India, and the Australian Constitution, which has been ensuring the protection for mentioning the Australian section 116, guaranteeing the freedom to access the religion, which is the prior thing which we can call it as, and the second dimension which you led us on, employed freedom of communication, of doctrine, of expressive conduct. Certainly this is something which has led us also to think about the protection of human rights. Right from the Constitution is evident that how Australia government is also concerned about the welfare of its people. Certainly, sir, thank you so much for this. And really, it is a point where we can also create it, that it is important that going on the matters judiciously, this is an important thing. Whenever the matter is brought before the court, the right is here how judiciously, expeditiously trial can happen. Rather, we should focus upon, we must suppress the mischief and pass the remedy which can protect the faith over the judiciary for everyone. Thank you so much, sir. Now, in the honor of Professor Stephen Wagner, I'll be going with the citation. I'll request the Rupinder sir, Jane ma'am. Before I go with my vote of thanks, I request the.
I'll just share. Just a minute, ma'am.
All right. Thank you so much, ma'am. This is indeed an honor for us to go and felicitate with you. Virtual citation. Thank you, ma'am. So in the honor of all the keynote speakers for the session of International Conference, I extend gratitude to you. I begin with the citation which is presented to Professor Stephen Wagner in the keynotes speaker session of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. Professor Wagner is an academician par excellence and an expert in the field of comparative history of legal methods and common law world. He has several accolades to his credit for the outstanding contribution through research in the field of comparative law. And we are thankful to Professor Wagner for sharing his valuable time and enlightening us with his key words on wisdom and of his wisdom. We hereby recognize the contribution made by Professor Wagner and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you, sir. Now, the citation is presented to Professor Paul T. Babi in the keynote speaker session of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. Professor Babi is a pioneer in the field of property law and religion. Professor Babi is an exceptional orator and has huge interest in disseminating the understanding of law across the globe through his research work. We are thankful to Professor Babi for his awe-inspiring words of wisdom and for gracing the occasion. We hereby recognize the contribution made by Professor Babi and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Now, the citation is presented to Professor Umakant Varatil in the keynote speakers session of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. Professor Varatil, an academician who specializes in comparative law on matters of mergers and acquisitions and corporate law. His interest in the area of corporate law is visible in the zeal with which he approaches the matters of corporate laws. We are thankful to Professor Varuchil for investing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Professor Varuchil and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. The citation is presented to Dr. Subhajit Basu in the keynote speaker session of International Conference on Comparative Law on Saturday, the 11th day of February 2023. Dr. Basu is an educationist specializing in information technology laws, focusing on making consumers empowered and better informed. His expertise in IT laws has significantly contributed in transforming the lives of people through the several research work he has undertaken. We are thankful to Dr. Basu for sharing his valuable time in enlightening us with his words of wisdom. We hereby recognize the contribution made by Dr. Basu and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. The citation is presented to Mr. Ranveer Kumar Singh in the keynote speaker session of International Conference on Comparative Law on Saturday, the 11th day of February 2023. Mr. Ranveer, a lawyer par excellence, has practiced in a wide spectrum of legal matters. His expertise also resides in the area of arbitration. He is a skilled professional and has a zeal to give back to the society and improves the life of people. We are thankful to Mr. Singh for inspiring us with his thought-provoking words and for gracing us with his presence. We hereby recognize the contribution made by Mr. Singh and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, School of Business and Law, Edith Cowan University, Western Australia. Thank you, ma'am. Now, I formally propose a vote of thanks. Indeed, it is a privilege to propose a vote of thanks and acknowledge the contribution of our learned honorable speakers. I, Suparna Vinayak, Assistant Professor, Amity Law School, Amity University, Uttar Pradesh, once again, on behalf of entire Amity Universe, express my deep gratitude for gracing the occasion and addressing us and creating a difference in our lives by making it evident that comparative study is the quintessence of development of municipal law. Adopting the comparative approach helps acquire a deeper understanding of one's own legal system by virtue of its ability to assess and appreciate the similarities and distinctions amongst legislations, legal institutions, political framework, social ideologies, policies, and rules prevalent in corresponding jurisdiction. With our sessions, we dealt on contract law, corporate law, artificial intelligence, responsiveness, and leading into adjudication of claims as mediation, commercial mediation, dispute resolvent, and with reference to constitutional rights to provide a guaranteeing life, that is something which is referred to as access to have our own religion. Going with this, certainly the definite aim is, however, for the betterment and strengthening of the domestic legal structure. So it is a great privilege again to be a part of this august gathering. I express my deep gratitude to Founder President Ashok K. Chauhan and our Chairman, Amity Law Schools, Professor Dr. D.K. Bandyopadhyay, and additional Joint Head of Institutions, Professor Dr. Aditya Tomar, Professor Dr. Shefali Raizada, and Professor Dr. Arvind P. Bhanu, and to the most important organizers of this international conference, Dr. Jane Matthew, ma'am, and Rupinder, sir. Thank you so much, sir, and ma'am, one and all present here. It is a great privilege to be a part of this 4th annual international conference, keeping this legacy ahead. Now with this, we come to an end of this keynote 4th session, and I request everyone to join the valedictory session of the International Conference on Comparative Law 2023 in collaboration with School of Business and Law, Edith Cowan University, Western Australia. Thank you everyone once again.
Thank you so much once again. It was a pleasure having all the distinguished panelists at this session. It was a wonderful discourse and we did learn quite a lot from this just one session itself. Thank you so much, all the distinguished speakers. Thank you. Thank you once again.
Thank you so much. Thank you.